Oh my goodness.
Okay, if everyone's ready to proceed, Gene, is everyone ready to go?
Yes, Your Honor. I have not received a text message. Have you?
I got a message that the practice has ended.
Yes, generally, Z will send a text message. But if we are ready to go,
All the parties there, can everyone hear?
and if we're being recorded, okay, I will open court, Your Honor.
Okay, please proceed.
The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to the Court of Appeals. We have 3 cases on our docket today. We will take those in the order they appear on the calendar. The first is State versus Stokley. Your panel today consists of me, I'm John Tyson, Judge Hunter Murphy, and Judge Toby Hampson. And if there's no other matters, we will hear from the appellant. Mr. Costanza?
Mr. Costanza, you're still muted.
May it please the court, I am Rich Costanza. I represent Mr. Stokley. I would like to reserve 5 minutes of my time for rebuttal, if that's allowed, please. Okay. In 1978, the Supreme Court handed down the Fulcher decision, which held that the restraint in some felonies like armed robbery cannot form the basis of a kidnapping conviction. Our appellate courts have revisited this issue time and again since Fulcher, and it seems that the results in the various appellate cases are driven by the facts of the individual cases before the courts. So I'd like to start just by discussing the state's evidence. The victim in the kidnapping case, Mr. Saunders, was in his room playing video games. An intruder came into his room with a handgun, gestured towards Mr. Saunders. Mr. Saunders followed him a short distance from the bedroom to the living room, where he was directed to get on the floor. At this time, the other victim, Mr. Beza, entered the house. One of the intruders directed Mr. Beza to get on the floor. And at that point, they were collectively asked where the money was in the house. They both had their cell phones taken from them. At some point, Mr. Beza got up and tried to run out of the door, and he was shot in the back. Mr. Saunders was still on the floor. He was not physically assaulted. He was not tied up. He was still on the floor when Mr. Beza was shot as he was trying to leave. He was restrained while his cell phone was taken. The robbery was still taking place during the time he was on the living room floor. Now, our North Carolina Supreme Court has handed down 2 opinions that are very consistent with the facts of this case. The first is Irwin in 1981. Irwin involved the robbery of a pharmacy where there were 2 employees in the pharmacy. One was near the soda fountain counter. One was near the pharmacy area where there were the drugs located. One of the defendants directed the clerk near the soda fountain counter to move towards the safe area of the pharmacy. That formed the basis of a kidnapping conviction. The Supreme Court found that that was a technical movement. It was part and parcel of the underlying robbery because the clerk was being directed towards the area where the drugs were located, where she could provide drugs to the robbers. Interestingly enough, in Irwin, the defendant actually shot and killed the other employee of the store. And the Supreme Court did not find that the surviving employee was exposed to any greater danger because of the killing of the other employee.
But Mr. Costanza, in the Irwin case, was that an indictment based just on a removal theory, or did that include restraint and confinement?
It was simply under a removal theory, according to the opinion. In the next case that I think bears discussion is the Ripley case from the North Carolina Supreme Court in 2006, where you have a hotel.
Before you move on from that one, let me ask you a couple of things. I think we all agree these cases are pretty fact specific. Do you agree with that?
Yes, Your Honor.
Is there any dispute that there was a aspiratation of Mr. Saunders from his bedroom to the living room of the home?
No, none whatsoever.
Is there any dispute that there was no robbery or nothing that occurred during that time?
The robbery started from the time the intruders entered the house with their guns drawn and began assembling the victims.
Was Mr. Saunders robbed immediately?
Mr. Saunders, he was relieved of his cell phone after he was taken to the living room and directed to get on the floor.
And his wallet, correct?
I believe Mr. Bize's wallet was taken. Mr. Saunders testified that his cell phone was taken.
Okay. Where does the break come between an aspiration and a restraint in connection with a robbery and where it becomes a separate offense? Where do we draw that line?
Well, in Ripley, the Supreme Court said the robbery began once the robbers, the perpetrators, entered the hotel lobby with their guns drawn. So there's not a clear break where you can say, an aspiration started before the robbery occurred, at least under the facts of this case. Now, there are some cases, one in particular from the North Carolina Supreme Court, where there was, if you give me just a moment, where there was a convenience store robbery. This is actually the Stokes case in 2014, where the robbery occurred, and after the robbery occurred, the defendant attempted to force the store clerk from behind the counter to get into a car to leave the convenience store. And in that case, you have a clear delineation from the robbery taking place, and then there's an attempt to remove the clerk following the robbery. Now,
did you also address State versus Boyce?
Yes, sir. In Boyce, you have a home invasion robbery where the victim is attempting to flee her house, and she's pulled back in the house by the defendant. The defendant effectively prevented her from escaping to get to a place of safety. And after her escape attempt is thwarted, after she's yanked back into her house, then she's robbed. So there you have a distinction between a separate movement, a separate aspiration, and then the robbery actually taking place, which is not consistent with the facts that we have here based on Mr. Saunders acquiescing to one of the perpetrators, directing him from the living room or from the bedroom into the living room.
You mentioned earlier the case where the pharmacy was robbed and one of the folks was shot and killed. Mr. Saunders here testified he felt the, quote, heat from the gunshot when Basil. Why doesn't that expose him to a, quote, greater danger separate apart from the robbery itself?
Yes. Well, you have Mr. Beza testified that he stood up while Mr. Saunders is still laying on the ground, and he turns to run, and he's shot in the back. The co-defendant that testified for the state gave the exact same description of the shooting, which is an indication that the gunshot was not directed towards the ground where Mr. Saunders was laying at the time. So again, consistent with the facts of Irwin, where you have one victim that is gunned down during a robbery. Here you have one person that's shot. Despite Mr. Saunders' testimony in the heat of the moment that he felt the heat of the bullet, I think the evidence shows there was not a gunshot directed at him. He was not in the line of fire. Now, Ripley, you have a hotel robbery in progress. The robbers are inside the lobby of the hotel. They see a set of guests that are entering the hotel. The guests notice what's going on. They try to leave. The robbers go to the entrance area of the hotel. They direct the guests to come into the hotel while the robbery is taking place. They're forced to the ground. They're relieved of their belongings. And the Supreme Court said that was a technical aspiratation being directed from the entrance area of the hotel into the lobby of the hotel. And what the court noted in finding that it was a technical aspiratation, they didn't address whether the guests were subjected to a greater danger, which is a factor the court should consider. Arguably they were, because they were removed from a location where passersby, people in the parking lot, could have seen what was taking place and alerted the authorities. We don't have that set of facts in this case. The state cites the Davidson case, where this court noted sometimes in robbery cases, if there's evidence that the victims were removed from a location where other eyewitnesses could see what was taking place and alert authorities, that would be a separate and distinct movement. Now,
does your argument boil down to that there wasn't really a removal, as the state argues, between the bedroom and the living room, or that a removal doesn't matter because a removal was not the indicted theory here?
My argument is that there was not a separate confinement, which was the theory that Mr. Stokley had to defend against, that can be separately removed from the actual robbery itself, that they were too intertwined with each other. But even if the indictment alleged confinement, removal, or restraint, the movement from the bedroom to the living room, he's on the ground, his cell phone is taken, it was not a separate and independent act. And this court has handed down two opinions that have horrific facts, where they've reversed kidnapping convictions, where there's much greater movement or restraint than the present case. The first is Cartwright in 2006, where you have an elderly woman. She hears something outside her house. She goes to investigate. Somebody forces their way in her house. She's held at knife point. She's choked with a towel. She's smothered with a pillow. Her night clothes are ripped from her body. She's robbed of $1, and she is raped. This court reversed the defendant's kidnapping conviction, focusing on the robbery. The victim was moved from the kitchen area down her hallway into the bedroom to get money. The court found that was inherent in the robbery. Regarding the sexual assault, the court found that she was restrained in the living room area during the sexual assault, and that was that overlapped, or that was inherent in the underlying sexual assault. I would contend the facts in Cartwright are so much more egregious than the case at bar, and it would be difficult to to come to the logical conclusion that the Cartwright defendant gets relief for his kidnapping conviction, but Mr. Stokley does not.
Let me ask a little bit about the purpose of the movement from the bedroom to
Yes,
the
sir.
living room. Originally, the indictment was about this $4,000 in U.S. currency,
Yes.
the drug money they'd gone there looking for. However, with the amended indictment, and this is on record page 12, it changed to cell phone and wallet, and there wasn't an objection to that. So with the fact that the purpose of this robbery and the focus in the indictment changed from generally finding money to this later activity of taking the cell phone at the very end of the encounter, does that change the purpose of the kidnapping? If the felony intent doesn't arise until later, how can the movement from the bedroom to the living room relate back for those purposes?
Okay. I would contend, and the record shows this, the victims were placed in a central location where they were asked where the money was. And regardless of the property that's alleged taken in the indictment, the purpose in and of itself was to put them in a central location, find out where the money was located in the apartment, and the evidence showed that when they were restrained in the living room, the perpetrators are going throughout the apartment looking for the actual money. I'm not sure the transcript reflects where the money was located, if it was within Mr. Baez's wallet. He did testify that his cell phone was taken. He testified, and Mr. Saunders said the same thing. I don't think that the transcript accurately reflects where the money was located and if it was contained in a wallet. The court heard State versus Payton in 2009, which involved a home invasion, armed robbery. A number of individuals forced their way into a house where there was a mother and her 8-month pregnant daughter. They were forced at gunpoint into their bathroom, where they were held in the bathroom for 10 to 15 minutes while the robbers took property from the house. In reversing the kidnapping conviction, this court reviewed the multitude of cases that have been litigated on this issue and made a statement that when a victim is bound up or physically harmed during a robbery, kidnapping may very well be the appropriate result. But if a victim is simply moved during a robbery but not harmed, kidnapping is not consistent with the intent of the legislature when they enacted the kidnapping statute. And this court noted that under the facts of Payton, that if kidnapping were allowed, then essentially any nonviolent movement of a victim could result in a kidnapping conviction, which was not the intent of the statute. And again, I would say that it would be difficult to logically say the Payton defendant gets relief from their kidnapping conviction, but the Mr. Stokley would not.
Mr. Costanza, what if Mr. Saunders had not been robbed at all? What if only Beza had been robbed?
If that were the case, I think the state has a stronger argument. The robbery indictment alleges both Beza and Saunders were robbed.
Right, but I'm wondering if the mere presence of someone at an armed robbery or rape, and they are kept or restrained, is certainly they're not a part of the other crime that's being occurred, right?
Yes.
So go back to the case of the woman and the daughter. Why wouldn't one of them be restrained if that person was not kidnapped or if robbed or sexually assaulted?
And Your Honor, I believe the record in Payton would indicate that they were both alleged as victims of or an armed robbery. So I think that's consistent with the facts of this case.
The passage of time, is that a factor as well?
Yes. Now, if, and this is going back to Judge Tyson, your earlier question, if there's a clear break, if there's a sexual assault or if a robbery takes place, and then afterwards there's an additional restraint or aspiratation, that very well can result in a kidnapping conviction.
How about a clear break on the front end?
I think the Boyce case from the state Supreme Court identifies that as a factor which led to the Boyce defendant's conviction being upheld. There, you have the China case from the state Supreme Court in 2018, where the defendant broke in his ex-girlfriend's house. Her boyfriend was there. He sexually assaulted the boyfriend, beat him, and then the boyfriend was laying on the floor after the sexual assault, and the defendant continued to kick and stomp him. There you have a break from the sexual assault to the additional restraint and brutalization that supported the kidnapping conviction.
So does our analysis here come down to how we view the time between movement from the bedroom to the living room and either the shot being greater danger or when the robbery occurred? Is that where the analysis comes down to?
And one other factor to that, Your Honor. In Durham, which is the unpublished opinion that I cited in my brief, this court noted that keeping the victims in a centralized location, and that Durham was a restaurant robbery where the victims were all herded, I believe, into the back of the restaurant. This court indicated that keeping the victims in a centralized location decreased the level of danger that they were subjected to. To your question, Your Honor, there are, I believe, 3 or 4 factors or commonalities between cases where this court has found a separate restraint, removal, or confinement. Were the victims tied up? Were they duct taped? Were they hogtied? During the restraint, were the victims physically assaulted? Were they beaten? Were they threatened? And did the restraint or confinement occur in a distinct time before the actual robbery or assault, or a distinct point in time after the robbery or assault? Those factors all lead or tend to support a kidnapping conviction. We don't have that in this case.
And the greater danger. There's the other element, right?
Yes, absolutely. And the courts have looked at, during the restraint, was there a gratuitous amount of violence that was inflicted on the victims? Were they placed in a more vulnerable position? Factors that this court and our Supreme Court has looked at where kidnapping is not appropriate. Were the victims moved to a centralized location with other victims, as opposed to victims being isolated from other individuals or isolated from potential witnesses that could alert the authorities? Was there an absence of gratuitous violence or assaultive behavior during the movement? And then this goes to the heart of the issue in this case. Was the confinement, removal, or restraint overlapping with the actual crime, the actual robbery, which is a very, I think, the strongest argument that I have in this case. Essentially, if the court allows Mr. Stokley's conviction for kidnapping to be upheld, it would create a precedent where anytime there is a short movement during a robbery from one location in a house to another, that a kidnapping conviction could be upheld. And I think that type of exemption would essentially swallow the rule in Fulcher. if that is to happen, that's a job for the Supreme Court. Yeah, yes, Your Honor.
Mr. Costanza, a few minutes ago in your conversation with Judge Tyson, you used the phrase clear break. And the way you used it was almost as a term of art. I just did a quick search on the 500 pages of cases I have here on my PDF, and I don't see that phrase showing up. Is that a term of art that courts have used in the past, or is it just kind of a summary of your view of the facts in the past cases?
That is, well, in the term clear break is just a colloquial expression that I'm using, but it was something that was identified in the convenience store robbery, where the robbery occurred, a gunshot after the robbery has occurred, the robber attempted to remove the clerk from the convenience store, and that was a factor that the Supreme Court cited. And I want to make sure I'm giving Your Honor the correct citation. I don't want to discount the indictment issue. I realize I'm running short on time. Mr. Stokley was put on notice that he had to defend against an allegation that there was a confinement that was separate and apart from the underlying robbery. The jury was not even instructed on that theory. Instead, they were instructed on removal and restraint.
Mr. Costanza, if I could jump in, and I know you're sort of pushing up against your rebuttal time, but let's say, assuming it was error to instruct the jury on a separate theory than alleged in the indictment, yes. Explain to me how, on the facts of this case, that rises to the level of plain error.
Okay. It was much easier for the state to secure a conviction based on the jury reaching a conclusion. Well, he was removed from the bedroom to the living room, and his cell phone wasn't taken when he was in the bedroom. So we can find a delineation between the removal from the bedroom to uphold a kidnapping conviction. This court has found plain error on this issue in State versus Bell. The Supreme Court found plain error on this issue in State versus Tucker. And in those cases, the plain error analysis, I think, came down to the fact that there was conflicting evidence. This case, we do have conflicting evidence on the issue of whether the confinement occurred during the course of the robbery. There's also evidence in this case of an alibi defense. Mr. Beza didn't initially identify Mr. Stokley as the shooter in the case. You had a co-defendant that gave 3 different accounts to law enforcement before testifying. He was allowed to accept a probationary plea. So I would ask the court to consider that issue. Obviously, if the first issue results in relief granted, then the second issue is moot. Thank you for your consideration, Your Honors.
Okay, Mr. Costanza, you have about 4.5 minutes left for your rebuttal.
Thank you.
Okay, we're here from the state.
Thank you, and may it please the court, Your Honors. My name is Raj Premakumar on behalf of the state. Before I begin, I want to apologize to the court for a typographical error in my brief in the table of contents. The argument seems to have been repeated twice, which is obviously an error, and I just want to apologize to the court for that oversight. Your Honor, I think the issue here, as you've identified before, or these types of cases, are very fact specific, and the key fact, as it applies in this case, is in one moment, Clinton Saunders went from innocently playing video games in his darkened room with noise-canceling headphones on to being accosted, held at gunpoint, moved to the living room where he was forced to lie down, and where he testified that he felt the heat of the gun as it was shot during the course of the robbery. So he was literally brought into the line of fire. And to the extent that there is an element of jurisprudence in these line of cases that requires exposure to greater danger, it seems to me that there's no question that he was exposed to greater danger by the removal and going into the living room. As I said before, he was in the line of fire. The other thing about the facts of this case, defendant argues that the robbery began sort of when the intruders came into the house, but the facts of the case indicate that the plan was always to rob Baeza, and that the knowledge that the co-defendant Williams had was that Baeza had the money and the marijuana. There's no indication in the record that these intruders even knew that Saunders was going to be there. And had Saunders had his door closed, it's not clear that Saunders would have ever known that there were intruders in the house. I mean, he had these noise-canceling headphones on. He was playing a video game. So the question of when the robbery started, I think, is key here, because it happened after the facts that support the kidnapping. Once he was brought into the living room, and once Baeza came into the living room from the garage, is when the armed robbery began to happen, because they didn't have any knowledge of Saunders first even being there, and secondly, that he had any money at all.
Well, I think you've got a pretty good argument if we were dealing with a removal case, but that's not what the grand jury found when they made the indictment. They only found confinement. So is the fact of removal at all relevant to our consideration of the robbery here and the kidnapping here, given that the kidnapping is limited to the confinement theory?
Well, Your Honor, in State v. Gainey, this issue of the variance in the indictment and the jury instruction came up, and the Supreme Court in Gainey found that given the strength of the evidence against the defendant, there is no reasonable basis for us to conclude that any different combination of the terms confine, restrain, or remove in the instruction would have altered the result. So the Supreme Court...
That's the plain error analysis portion, though, right? That's not the motion to dismiss portion.
Well, that's correct. But in the motion to dismiss portion, Fulcher stands, the seminal case in this context includes this language: the term restrain, while broad enough to include a restriction on freedom of movement by confinement, connotes also such a restriction by force, threat, or fraud without consent. Now, so if you read that language, it would appear as though confinement is subsumed within the meaning of restrain, or can at least be interpreted to be subsumed within the meaning of restrain, particularly in a situation where we're not talking about a great deal of distance. The Supreme Court has said that you don't need to measure this with a tape measure. The question of confinement, restraint, and removal are all very closely tied together. And again, in Fulcher, the Supreme Court has held that confinement can be subsumed under, or at least can be found. The definition for confinement can be found within the definition of restraint.
Right, but that still doesn't get us to the removal theory. So I don't think that we'd say there's a confinement or restraint in leaving the bedroom until he gets made to get down on the floor in the living room. So in that part, we just have a removal. We don't have a confinement or restraint until the living room, correct? Or am I missing something there?
Well, I think that's correct, Your Honor. And in Irwin, they apply the same standard of this separate and apart behavior conduct from the armed robbery to removal as well. I think that the removal, restraint, and confinement, although they are separately defined terms, interweave in the context of these cases. And it is sometimes difficult to parse out what would be confinement versus what would be removal versus what would be restraint.
If someone's held at gunpoint, are they restrained and confined without being removed?
Yes, restraint by being held at gunpoint has been found by our courts to satisfy the definition of restraint. It's like
so the kidnapping stand here if Mr. Saunders had not been removed from his bedroom.
I believe that could be Yes, I think the facts of the case would allow for a second-degree kidnapping charge to go to the jury based on the facts of this case.
So if he was held in his bedroom at gunpoint and everything else happened, the robbery, the shooting, everything else, that would support a separate kidnapping, even without the movement to the living room?
I think you would have to look at the issue of confinement in that context as to being confined to the bedroom in which he was located.
Or restrained in his bedroom, right?
Or restrained in his bedroom, because the restraint, if you look at State v. Piggott, in the North Carolina Supreme Court said that all of the restraint necessary inherent to the armed robbery was exercised by threatening the victim with the gun. That was all that was needed for the restraint in the armed robbery context. And I think that confinement and restraint would be the result in your hypothetical, Judge Tyson. So the other issue is, was this
Before you move on, let me ask you one other thing.
Yes, Your Honor.
Is the state's theory here to support the kidnapping a movement from the bedroom at gunpoint to the living room and then some lapse of time? And or is it a greater danger by virtue of feeling the heat of the bullet, or both?
Your Honor, I believe it's the latter. I think it's the exposure to greater danger. That has been a consistent through line in these cases in determining whether a second-degree kidnapping charge or a kidnapping charge in the first degree could maintain. And it is the exposure to the greater danger aspect of it that I think clearly applies in this case.
Then how would you distinguish defendant's case on the robbery of the pharmacy with one person being shot and killed?
In that case, Your Honor, the court found, would that be the Irwin case that you're referring to? That would be the case where the pharmacy, where the person was moved back to the back of the pharmacy to get access to the drugs. So that was a situation where it was not in my view not the exposure to greater danger necessarily, but it was also the inherent and inevitable course of conduct of the armed robbery, because the drugs were located in a place where the person was removed to. And so you have both in that situation, you have the inherent inevitable course of the conduct that was part of the armed robbery. And then there's also the exposure to the greater danger.
But there were two people involved there too. There was a clerk and there was a movement, transportation. And then one of the two people was shot, just like you have here. And the court in that case didn't find a greater danger, did they? Even though someone was shot and killed.
No, Your Honor, they did not. But I think that the facts of this case would also indicate that there was clearly a greater danger from being moved from his bedroom into the living room. Whereas, he could have been, it is entirely possible that had this been a robbery that was intended to rob the whole house, or all the occupants of the house, whether they knew they were there or not, all the restraint that was necessary to commit that was at the point at which he held the gun in the bedroom, and he could have removed the cell phone from Saunders in the bedroom without having to move him into the living room, and that would have been sufficient to conduct to inherent in the armed robbery in that situation would be being held up in his own bedroom. But in this case, he wasn't. He was moved from the bedroom into the living room, thereby being exposed to greater danger. And I think, as in the case in Boyce, the court found that it doesn't take a lot of distance. Distance is not the issue. In Boyce, the woman was trying to escape, went 1 foot outside of her house, was pulled back in, and that was sufficient. And again, the other thing here is that if you look at the kidnapping as happening before the armed robbery, then it does flow that this was a separate course of conduct. Because in Davidson, this court held that the movement of the people into in the dressing room constituted what they were trying to do was to hide the people from passersby and to prevent hindrance of the commission of the armed robbery. And I think you could say here what they were attempting to do was to move Saunders from the bedroom into the living room to prevent Saunders from escaping or to prevent Saunders from otherwise hindering their attempts to rob Baeza, which would be a separate course of conduct issue as well, in line with the case in Davidson.
How do you, two questions here. Counsel for the defense has said that when you mass people together, there's less danger than there is when you isolate them. And the other issue is Baeza was robbed and shot and charged, and the defendant was charged with kidnapping. But in that case, the trial court did dismiss that kidnapping as it relates to the shooting and the robbery of Baeza. So why was that dismissal proper, and this one shouldn't be allowed to stand?
Well, the first degree kidnapping, Your Honor, involves the issue of second degree kidnapping involves whether you're left in a safer place and not exposed to sexual violence as well. I think the first degree kidnapping didn't meet that element when it was charged as against Baeza, because he wasn't removed or restrained in the same way that Saunders was. Baeza came into the living room and then made a break for the door, and I think that the first degree kidnapping charge was dismissed on the basis that it didn't meet the criterion for the elements submitted to the jury.
Would there be enough for second degree kidnapping on Baeza?
You know, I think actually it could have been charged. The fact that it wasn't, I'm not clear as to why, but I think it could have been charged, and I think it perhaps would have been resulted in a conviction on that charge as well. And your first question, Your Honor, I'm sorry, I think could you repeat the first question? You had two.
Judge Tyson, we've lost your audio.
I think defense argued that when people are massed together, there's less danger than being isolated and keeping people apart.
Thank you, Your Honor, and I apologize for that. I think the issue, though, is on the facts of this case. You know, there was a gunshot that was fired close enough to Saunders to where he felt the heat of the bullet. In the case of Featherston, where they were placed and bound together on the floor, there were no shots fired. In the case of Cartwright, this home invasion rape, there was no greater danger. It was a knife attack, and there was no greater danger that was applied. Moving people into a centralized location may create a situation where they're at less danger, but it depends on the facts. And the facts in this case are he was clearly moved into a situation where he was exposed to greater danger because that's where the gunfire occurred. He would not have been exposed to the gunfire had he been left in the bedroom or even robbed in the bedroom. He would not have been in the crossfire, or he would not have been in the line of fire in that situation. The greater danger existed once he was moved into the living room.
Where does the burden lie in deciding if it was a distinct action or not? Does that burden lie with the state, or does it lie with the defendant in the cases?
I think the burden lies with the state, Your Honor, and I think the state in this case, the facts of this case as they were adduced at trial show that there was clearly a removal and a restraint, and also actually a confinement, if you want to expand using the Fulcher language as the basis for considering this holistically. I think, and the state, I think, met that burden in submitting evidence to the jury. In these close cases, of course, the question is, should the jury be allowed to make a decision based on the elements of the crime being introduced by the state? And I think that happened in this case. So basically, just on the issue of whether the second degree charge should have been dismissed or submitted to the jury, you know, we have a a separate course of conduct, arguably, that they were trying to prevent Saunders from hindering their crime of robbing Baeza. You have a temporal issue in terms of the second-degree kidnapping occurring prior to the armed robbery commencing, in that the movement of Saunders to the living room was not an inherent and inevitable part of the armed robbery, because, as I indicated before, there's nothing in the record to suggest that the perpetrators knew that Saunders was going to be in the house at all, and Saunders certainly wasn't expecting to be accosted at gunpoint when he was in his bedroom playing video games. So there's separate course of conduct issue there, and more broadly, it was not an inherent and inevitable that Saunders would have to be moved to the living room in order for the armed robbery to be effectuated. There's no evidence in the record that there was money that they even went into Saunders' room to find anything or rob him of anything.
That's the allegation in the indictment, though, right? So how do we separate that? You know, the indictment says the intent was to rob from Baeza and Saunders, and they're both of their lives were threatened. So I don't think we can confine it to that they just went in there to rob Baeza and not Saunders. Can we?
I think at the point at which Saunders was in the living room, at that point there certainly was a joining of those two individuals, but there's a separate step that occurred, and that was moving him out of the bedroom into the living room to conduct the armed robbery, which then later occurred.
But if the intent to rob Saunders doesn't arise until later, when they're in the living room, then we don't have an underlying felony for the kidnapping intent, do we?
Well, I think under confinement, you would, with confinement and restraint. Remember, in Piggott, all the Supreme Court said that all the restraint necessary and inherent to the armed robbery was exercised by threatening the victim with the gun. He was still threatened with the gun when he was lying on the floor in the living room, and then the gunman, the defendant, then threatened Baeza when Baeza came into the house from the garage. And so that created all the restraint that was necessary for the armed robbery occurred at that point, which is a separate restraint and separate from the removal that happened from the bedroom to the living room. Your Honors, with regard to just moving on to the other issue about the plain error, the standard for plain error, of course, is extremely high. It has to applied cautiously and in the exceptional case, as per the court in Odom. It's a fundamental and a probable impact on the jury's guilty verdict. I think defendant was correct. Counsel for defendant was correct in the analysis that it has to do with highly conflicting evidence or sharply conflicting evidence that would lead to a plain error ruling. And the case Bell that defendant cites, the victim gave very differing accounts as to when he was restrained, how he was restrained, where he was found. There's a lot of questioning. In this case, however, there is not sharply conflicting evidence. You have Baeza, who identified the defendant. You had Williams, a co-defendant, who identified the defendant. Obviously, Saunders was competent to testify as to that there was a gunman who moved him from his bedroom to the living room. The alibi defense, I don't think it can be fairly stated that the alibi defense creates sharply conflicting evidence here, because the jury convicted the defendant of assault with a dangerous weapon and robbery with a dangerous weapon. So the jury obviously did not find the alibi defense, the uncorroborated alibi defense, to be particularly persuasive. And so the question is, would this have resulted in if the instruction had been to instruct on confinement, would there have been a different result? And the court in Gainey stated that we cannot conclude that had the trial court instructed the jury that the defendant had to confine the victim to be guilty of first-degree kidnapping, this would have tilted the scales in favor of the defendant. There's any different combination of the terms confine, restrain, or remove in the instruction would not have altered the result. And that's the same case we have here, because in that case, in the Gainey case, the indictment was on confinement and the instruction involved removal and restraint. And what the court was saying here is it didn't frankly matter because the elements were all met, and the jury would not have reached a differing result. So I think that also applies in this case, and I think that if there were error, it is certainly not plain error.
You also mentioned earlier that Fulcher has language that says restraint subsumes confinement, right?
It doesn't say subsumes confinement. That was my reading of it, but it says it's broad enough to include a restriction on freedom of movement by confinement. So I think in that, if you were to apply the terms as used in Fulcher, there is a sense that confinement is within a broader definition of restraint. And of course, Irwin applied the same concept to removal. So that's why these concepts of confinement, removal, and restraint are somewhat tied together. One can fit within another, and it really is fact dependent upon how the courts have held their decisions in these cases based on those terms.
If that error had been preserved under a regular preserved error standard, would the defendant be entitled to a new trial?
Well, I think the heightened standard for it not being preserved creates a bar. As to whether it would be sufficient to render a new trial had it been objected to, I think it's a close case. I think it's possible, but
so my question is more specific. Was it error but not plain error, or is it not error at all because confinement is subsumed within restraint? That's my question.
Well, Your Honor, I'll answer that question by saying that it's sort of both. It's not error in the context of the definition of confinement being subsumed under restraint, but if this court were to find that were error, it would not rise to plain error. I think that Fulcher does stand for the proposition that confinement can be subsumed under restraint. And if that is the analysis that applies here, then it would not be error at all. And there would not be a new trial needed, even if that had occurred. But going further, if it was error, as in the case in Gainey determined that it was error, but it was not plain error. And that the case in Gainey tracks a lot with this case because of the indictment on confinement and the instruction on removal and restraint. That's exactly what happened here. The court in Gainey found that was error, but that it was not plain error, that the jury would not have reached a different result had confinement been instructed. And I think here in this case, I don't think it's the jury already had discounted the alibi defense, and what they had was eyewitness accounts from two individuals who testified that it was the defendant who had committed both the kidnapping and the shooting. So
well, it's three. You had the co-defendant testify, then you had Saunders and Basis. So there were really three separate testimonies.
Really three, although Saunders wasn't able to identify the gunman. He certainly knew that he had been taken from his bedroom by a person who was later identified to be the gunman by both Baeza and Williams, the defendant and the other victim.
Now, circling back to error versus plain error, wouldn't the inclusion of the non-indicted theory of removal under State versus Tucker and State versus Bell constitute error regardless of whether we determine it's plain error or not, or whether we decide it's reversible error? I mean, looking at those cases, it seems clear to me that the inclusion of a non-indicted theory on kidnapping is error.
Well, that's and Your Honor, in Gainey, that was, I think, the result that occurred. What we would argue is that if the language of Fulcher contains at least the conceptually the concept that confinement could be subsumed under the restraint theory, but you are correct, Your Honor. I mean that is, I think, were you to find error, then the question then becomes a plain error situation. It's just a question of whether the jury was sufficiently would have reached a different result had the proper instruction been given.
And looking at Fulcher, looks like the date of offense in Fulcher was September 8th of 76. And I count at least 1, 2, 3, 4, 5, 6, 7 amendments to our kidnapping statute since then. Do any of them change the approach on confinement, restraint, or confinement being subsumed by restraint?
No, Your Honor, I don't believe so. I think the Fulcher, I think the principle in Fulcher has remained constant, and it's really the seminal case in this line of cases. And I don't think it's been affected by revisions to the statute.
And I'm also looking at pattern jury instruction, criminal 210.35, which gives a definition. It lays out 3 different theories: confined a person, restrained a person, and removal. For confined, it gives confined a person, that is, imprison the person within a given area. For restrained, it sets restrained a person, that is restricted the person's freedom of movement. Those definitions on their own are a little bit different. There may be some potential for overlap, but those definitions are different. Are you suggesting that portion of the pattern jury instruction isn't supported by any case law that provides different definitions of those terms? I will note there's no footnote that I can find on that point. So that may just be the case, but I wanted to ask your thoughts on that, looking at the pattern jury instruction having different definitions for those 2 terms.
I don't think that that's borne out by the case law, insofar as if you go back again to Fulcher, it says it's broad enough to include restriction of freedom of movement by confinement. Restraint is broad enough to include that definition. So to the extent that there are different definitions, I don't think that the court in Fulcher was itemizing them in that way. They were trying to create the framework for which these kidnapping cases could be evaluated. And so restraint, while broad enough to include a restriction of freedom of movement by confinement, connotes also such a restriction by force, threat, or fraud. And the threat here in this case, of course, is the threat of the gun.
Would that be something like something that is best subsumes something that is better?
I think that's an appropriate way of putting it, Judge Tyson.
If you got the best you can, that would include anything that
would include better, that's for sure.
Yeah.
So, Your Honor, with respect again to the motion to dismiss being denied, I think the court correctly submitted the second-degree kidnapping charge to the jury, and the variance in the indictment and the instructions, if error was not plain error, such the jury would have reached a different verdict had the confinement theory been included in the instruction. And for those reasons, Your Honors, I would respectfully request that the court find no error in this case and affirm the trial court's ruling. Thank you, Your Honors.
Okay, thank you. Any other questions of the state? Okay, then we'll hear from the defendant on rebuttal. Thank you.
Thank you, Judge Tyson. I was asked earlier about phraseology I used as far as there being a clear break or delineation from the underlying felony and then any additional restraint. It was the Stokes case from the North Carolina Supreme Court, convenience store robbery, where the clerk handed over money, I believe a carton of cigarettes, and then after that occurred, the defendant demanded that the clerk attempt to leave with the robber in a waiting car. And the Supreme Court noted the armed robbery was complete and defendant's attempted removal of the clerk therefore cannot be inherent to that crime. The court goes on to note, by ordering the clerk into an awaiting automobile after completing the armed robbery, the defendant attempted to place the clerk in a greater danger than that inherent in the underlying felony. Now, this same concept of there being the armed robbery And then a separate kidnapping following the armed robbery was noted in the Piggott case cited by the state, where it's an armed robbery. The victim is restrained, his hands and feet are tied, and then the defendant searches, I believe, an apartment complex for money or property to take from the victim. Then he goes back to where the victim is restrained and hog ties him, ties his hands to his feet. And the Supreme Court found that that was a separate and distinct restraint from the initial confinement that overlapped with the underlying robbery. So that's another case supporting the argument that if there's a clear break from the underlying felony and a later confinement or restraint, that kidnapping is appropriate. Of course, we don't have that here.
What about a case here where the robbery did not occur until sometime after the movement?
Okay. Which is consistent with Ripley, where you have victims that were not contemplated in the original robbery, which is something that opposing counsel mentioned, that Mr. Saunders was not a contemplated victim. The guests that showed up during the course of the robbery in Ripley were herded into the lobby, placed on the floor, and they were subjected to an armed robbery. The state cited the Davidson case, and in Davidson, you had the victims were forced into a dressing room. They were their hands, their feet, their heads were tied, and no property was taken from the victims while they were in that dressing room, nor was any property taken from inside the dressing room. So that case, I believe, is distinguishable. Regarding the second issue, the indictment issue, the state relies on Gainey. In Gainey, you have a defendant who confessed to meeting the victim near a church, taking the victim at gunpoint from a church to an area near the defendant's house. He shot the victim there, put the victim in a comforter, and then put the comforter in the trunk of his car. The victim was then drove into a wooded area. The victim was still alive, crying for help. The victim was dragged into the woods and was shot execution style. So the Supreme Court had no problem finding, regardless of how the indictment was phrased, there would be error. And I believe my time's up. So I thank the court for your consideration, and would ask you to award Mr. Stokley relief on the kidnapping conviction.
Okay. Any further questions of the defendant?
No, sir.
Judge Hampson?
No, I'm good. Thank you.
Okay. All right. Well, thank you, gentlemen, for your good arguments. And it's an interesting question of law and very fact specific. We appreciate the good arguments from both sides. And with that, this case is submitted, and we will go on to our next case on the docket.
Thank you, Your Honor.
Thank you very much.
This session of the North Carolina Court of Appeals is now adjourned. And Your Honors, you will have to log out and log back into the next session.
Okay, Gene, I think we probably just need to recess because it's the same session, but we'll come back in for our next.
Okay. Yes, sir.
All righty.